Mr. Sumit Chander. Mr. Chander, your opening remarks, what are your expectations from the Supreme Court? We've all been avoiding any second guessing here, but tell us a little bit about Section 43D5 of UAPA and how that changes the normal principle of bail, not jail, because much is being spoken around this section.
See, 43D of the UAPA, that is what it is revolving around today. It clearly says that bail cannot be granted if on perusal of the final report, the court finds that there are reasonable grounds for believing that the accusation against this person is prima facie true. Now, what is the threshold of this 43D is what is going to be decided by the Supreme Court today, to what extent it can go. This provision of law, Section 43D, is the only exceptional provision which says that jail is the rule and bail is the exception, which is normally the other way around. So, since it makes jail as a rule itself, all the court now needs to see is to what will be the threshold of 43D and what will be the extent to which you can assess and call it a prima facie case.
Well, absolutely. And Mr. Chander, you speak of 43D, and also if you look at the police case in this entire matter, they basically say that these riots were not spontaneous, they were pre-planned. In fact, this was an attempt to make the matter international, because then the US President, Mr. Donald Trump, was visiting India. And also this very damning speech, the video of that speech which Umar Khalid made in Amravati, which has also been presented before the Supreme Court during these proceedings on bail. Do you think all these matters together make the case of Umar Khalid very difficult and difficult for him to get bail in these circumstances?
Yes, in fact, like I said, the court at this stage cannot deep dive into the facts of the case. It has to go by what is prima facie on record it has come. And it is on record. There is a funding, there's a trail of the funding which has come through NGO fronts and shell companies. There is shifting of communication from open platforms to encrypted apps. Why they needed an encrypted app to communicate. Then while they were getting arrested at that stage, they deleted some chats before the arrest. Now, Section 8 of the Evidence Act makes it very clear that conduct is an evidence of guilt. So, if before arrest their conduct is such that they are trying to hide something, that will also be taken into consideration, at least as a prima facie case, which today the Supreme Court will assess and decide the matter on.
Okay, Mr. Chander, on that note, where does the law draw the line, Mr. Chander, between political speeches and, let's say, criminal conspiracy only under UAPA?
See, free speech, as my learned friend Mr. Singhvi has rightly pointed out, that free speech is of course protected under Article 19(1)(a) of the Constitution, and everybody has a right to free speech. But there is a bar, a small bar. That small bar is that where it crosses into an incitement, then it becomes an offense under the criminal law. Now, whether it has crossed in this case or not,
so
again,
there has to be a direct call to violence.
There has to be a direct call. There has to be an incitement. There has to be people getting agitated with and getting aggressive with the speech and taking actions. Now, in the present case, what I understand, of course, the facts needs to be analyzed by the court. But in the present case, there have been evidences of speeches and chats where they have spoken about paralyzing Delhi by initiating a chakka jam. There have been speeches where they talked about blocking essential supplies or cutting critical corridors. Then there are witness statements, very interestingly, which say that, let's stock acid bottles, cover CCTV cameras. Now, if all these things are a entire coordinated, and not only just coordinated, it is the coordinated during the time very clearly when the US President's visit was to take place. So all these aspects will be seen overall. These facts will be considered while deciding the bail in this case.
And is it legally possible to prosecute someone under UAPA without proving that they were present there at the moment, at the time of the riots? That's another thing being contended by the defense here.
Let us be very clear. This is a stage of bail. The court will not dig deep into the facts of the case, onto the evidence at this stage. It is today only to see whether a prima facie case is made out or not based on the report filed by the prosecution. So that is where we are today. So what will happen, what evidence will come up, and how it will be taken in the conclusion is a separate matter. At this stage, only a prima facie case has to be looked into while deciding the bail.
Okay, Mr. Chander, what if a bail were indeed granted? in your view, and what's the sentiment? I'm just trying to understand the sentiment in the legal community as we speak. Could that then mean weakening of UAPA prosecutions? Is that the feeling if that were to come from the Supreme Court?
See, like I said, this is going to be a very important judgment, whatever will be decided, because it will affect the entire, so far as the UAPA law and the overall criminal law is concerned. This is an only exception, like I said, in the UAPA Act, where 43D says that jail is the rule, unlike it's normally the other way around. So, but in this case, it says that there has to be reasonable grounds for the court to believe that the accusation is prima facie true. Now, if you get into prima facie true, how much broad can you expand into deciding what is prima facie view? That is what the court will now look into. Of course, every case is dependent on its own facts and circumstances, so the court will look into the facts of this case as well, and then take the decision. But yes, in whatever manner, the court will somewhere make it very clear that if you're talking about a prima facie case, so far as 43D, then of the UAPA Act, then the court, what is the threshold of that and to what extent that can be done. So that is what will be decided today while deciding the bail.
Well, absolutely. And also, this point, I feel that the defense has been also been arguing Article 21, basically saying if you prolong incarceration for somebody without the conclusion of trial, how far is that also justified? Because the supporters of Umar Khalid actually term him as a political prisoner. And you've seen international support also coming for Umar Khalid, specifically the recent one by the new mayor of New York, writing to him and saying that they stand by him. Do you think all these factors are also in a way building that support for Umar Khalid when he comes to the Supreme Court asking for bail?
See, normally, even the, like we call the media trials, the courts are not to get influenced by any external pressures or any kind of a force. A court is an independent authority. It is a judiciary, is supposed to be independent. It is not to get influenced by any statements made by either the media or some political people. The court will have to decide the case on its merits as per the law which has already been framed by the parliament. The parliament already has a law in place, which is the UAPA Act. The court cannot make new laws. It has to interpret the laws. So let us be very clear. Courts are also limited to the provisions of law which are already enacted. It only has to uphold the constitution the way it is. It cannot go and create new laws. So let us be very clear that so far as today is concerned, the court is only going to interpret and say what is the threshold of 43D and not go beyond that.
And the other point being made by the Supreme Court, Mr. Chander, is incarceration only due to mere passage of time cannot be considered punishment. Deprivation of liberty should not be arbitrary. Are you picking up of early signs on what could come in from the Supreme Court, Mr. Chander?
I think it is my assessment on this, and that is what I had told you initially also, that the Supreme Court will now decide the threshold on the 43D. I think it's going in a very similar direction because law will remain. And please understand, UAPA is a very special act. This entire law has been made with a special purpose, and it goes beyond what the regular criminal parlance is. Makes it more strict. It says that jail is the rule in this case, only for provisions under 43D of the UAPA Act. Now, when a special law has been made, makes it very clear. It is also the law that the courts at the bail stage cannot dig too deep into the facts of the case. So it has to take a prima facie view. And from the records available, as Mr. Dubey rightly pointed out, the court will go in its own.
And very important is dignified.
See, very rightly pointed out, Supreme Court has already, I think, from the initial signs of what is being said, Supreme Court also makes it very clear that the scrutiny, it does not take away the judicial scrutiny. So the act is there, but what the court needs to see now is if the prosecution material shows the offence is alleged or not. Now, these are the things which the courts are going to assess from the documents available. It has obviously heard both the sides. So now what will come up, one, of course, is each case is based on the facts, but also in the present case, what will be the extent that the courts can look into when deciding a prima facie case so far as 43D is concerned. And that is what is going to be decided along with other facts which will the court will assess on the basis of the documents, statements of the witnesses, and then take a concluded stand today.
So, if we read out more of the
Right.
observations coming from the court, Mr. Chandra, very importantly, the court is speaking very strongly on this being a terrorist act. What the court is saying, that the ordinary assessment of person's liberty is different when cases are of threatening the foundation of the state. The court needs to see if the prosecution material shows the offences alleged, if material shows unlawful activity as defined under the act, whether statutory threshold is crossed by the accused. And very importantly, the court is saying that terrorist acts not only are violence, but also include disruption of essential services. The act reflects Parliament's reflection that threat to society may arise even in the absence of immediate physical violence. Very importantly, the court is also saying, Mr. Chandra, that all accused persons do not stand equally, treating all the accused equally would promote pre-trial detentions. Court must be careful not to confuse between determination of criminal liability and concern of bail. Umar Khalid and Sharjeel Imam stand on a different footing from others. Mr. Chandra.
See, like I rightly, I had said the similar thing earlier, that definitely things are different. Every accused will be treated differently as based on the facts and whatever is being alleged against them, what are the evidences against them. Now, there are witness statements which are very clearly that there were speeches which talk, and witnesses have themselves said in the speeches it was decided that they will cover CCTV cameras, they will stock acid bottles, they will coordinate the protest sites. So, if all those things are on record, then, like Mr. Verma rightly pointed out, courts will, of course, go into a prima facie view. A direction needs to be taken. But having seen this, what it now seems is since very clearly Umar Khalid and Sharjeel Imam are now clearly by the court has held that they are on different footing from the others. The court, it appears, may or may not possibly grant them a bail, but definitely will speed up the trial. That's I think, to a maximum, that is what is going to happen. But it seems very unlikely that a bail would be granted to these two accused.
Well, absolutely.